Good afternoon and good morning. So good afternoon in India, good morning in Greece and in the Netherlands. My name is Aurélien Orange, and I will be hosting this match for the Corax Foundation. This is the Inter-University Law Debate Tournament, the 8th edition. This is the day one match, so the start of the competition for two teams. These two teams are actually starting with a topic connected to state responsibility and environmental law. And the two universities represented by the two teams are Desh Bhagat University in India and the National and Kapodistrian University of Athens in Greece. These two universities are presenting for the very first time debate teams, so this is the entry actually in this edition for the two universities. And we are very happy, of course, to welcome them and to see their first official debate in the history of this competition. So I would like to give the floor to each student now, alternatively between the two institutions, to introduce themselves. So we'll start with Miss Pelagia Stamataki. Welcome.
Good morning or good afternoon, everyone. My name is Pelagia Stamataki. Usually they call me Pelina. I am a fourth-year law student in Athens, and I'm excited to be here with people around the world that I never thought I would be having this conversation with. I think it's beautiful. I'm really honored.
Thank you and welcome. I have to give the floor now to Miss Sonali Gupta. Welcome.
As of Indian Time Standard, good afternoon to all present here. I, Sonali, of Desh Bhagat University, India, student of 4th year BLB Honours. Here, I'm here. I'm just glad to be here in this competition, the first match we are having with our opponents, and so feeling proud about this moment. And all the best to all of my opponents at come friends. So let's get to this competition.
You're welcome. Thank you very much. And now I give the floor to the second member of the team, of the Greek team, Mr. Leonidas Tsaoutis. Welcome.
Thank you. Hello, everyone. My name is Leonidas Tsaoutis. I'm a second-year student in the University of Athens, and I hope we have a great match today.
Thank you. Welcome. I welcome now the second member of the team from Desh Bhagat University, Mansha Kana. Welcome.
Jai Hind, Namaste, good afternoon to everyone presented here. My name is Mansha. I'm from Desh Bhagat University from India, a final year law student. I'm glad to be here to be a part of this debate tournament, and also thanks to the organization. Thank you, and let's hope the best will win this match. Thank you.
Thank you. Welcome. Now, third member from the Greek team, Maria Berketti. Welcome.
Hi everyone, good morning and good afternoon. I am Maria Berketti. I'm a third-year law student at the University of Athens, and I'm wishing everyone a fruitful debate today. Good luck to all.
Thank you. You're welcome. In the room, there is one coach who is present, so welcome as well to Glory Oyesani.
Thank you very much, Mr. Orange. Good morning, everyone, and I hope that you have a fruitful and enlightening debate.
Thank you. So, the topic which was sent a week ago to both teams is connected to the theme of this day one of the group phase for all the universities. So this unique topic for this match is states have a legal obligation under international human rights law to ensure that climate change adaptation measures do not violate the rights of indigenous peoples. So now we share my screen and we'll know live which position each team will have concerning this match. So in a few seconds you will see on YouTube and on WebEx the allocation, the wheel itself first. So as you can see, there are two chances for each institution, one chance to be in favor of the motion and one chance to be against the motion. So now we'll click on the wheel to activate the randomizer, and the team in favor will be starting the match. So this is the National and Capodistrian University of Athens will be against the motion. As a consequence, Desh Bhagat University will be in favor and will be starting the match with the first introduction. So it means concretely that Desh Bhagat University will defend the position that states have legal obligation under international human rights law to ensure that climate change adaptation measures do not violate the rights of indigenous people, while the National and Capodistrian University of Athens will defend the position that states do not have a legal obligation under international human rights law to ensure that climate change adaptation measures do not violate the rights of indigenous people. So now both teams will have 5 minutes to review their notes, and then after 5 minutes we'll start the introduction by the team from Desh Bhagat University. You can close your mic and video during the 5 minutes if you wish. Here it is done with a 5 minutes of preparation. So before we start, I want to remind everybody that when you will see the yellow card, it means you have still 30 seconds to speak. So you can continue to speak. And when you see the red card, it means that you are supposed to finish your sentence and not start a new one. Otherwise, the judge might take this into account negatively in their grading. So now we start with the introduction from Desh Bhagat University. You have 4 minutes.
Today, ladies and gentlemen, esteemed judges and fellow debaters, today we gather here to discuss a critical issue at the intersection of human. Today, I stand before you to affirm the motion that states have a legal obligation to ensure that climate change adaptation measures do not violate the right of indigenous people. So let's cover the motion. Uh, but so International Labour Organization ILU Convention number 169 defines indigenous people. Who are the indigenous people? Descendants of population lived in a country before conquest, colonization, or state formation. Groups who retain part or all of their social, economic, culture, political institution under Indian indigenous groups as scheduled tribes under Article 342 of the Indian Constitution. What rights do they have? Under various international laws, and or we can say international humanitarian law. UNDRIP 2017 Article 26 and 27 defines endangered people who have the right to hands territories and resources they have traditionally owned or occupied. Article 32 state must have obtained free, prior and informed consent. FIPC ILO Convention 169 Article 6 and 14. Government must consult endangered people before making decisions that affect them. Recognizes endangered land rights and mandate legal protection. Under Indian Constitution, Article 244 provide a special provision for scheduled castes and scheduled tribes. Under Articles 371A and 371G grant autonomy to endangered people. So, as we can see, there are many legislation which provides safeguards to indigenous people. Let's cover in the favor of motion. My first argument states that in 2017, the Stand Rock Sioux tribe opposed the Dakota Access Pipeline in the U.S., citing threats to their waste supply and sacred land. Furthermore, this state states that the state obligation under climate agreement, Paris Agreement 2015, preamble and article 7 and 8, it recognizes indigenous knowledge are essential for a climate adaptation. Article 7 calls for participatory, transparent and inclusive climate adaptation and measure. Article 8 establish mechanism for loss and damage which must indulge in the indigenous constitute the first binding treaty to require indigenous people participation environment is the policy which is ACASU Agreement 2018 agreement Article 17 Latin America and Latin American Carberry case where case law which proves that state has the legal obligation. So as we can see, I will state two cases which are one of them are Ogezi case 2007, the African Court on Human Rights and People Rights. Second case is Supreme Court of India recognition of climate rights April 2024. Kenya. So first, let's see the worst case. Kenya violated the land right of Ozek people by evicting them from the Mau forest for conservative purpose. The Mau forest for conservative purpose, the court held that climate conservation cannot justify the violation of the endangered relevancy. It confers a CASU agreement 2018 Article 7, which mandates endangered people participate in the environmental process. It highlights that the need for justice and right based on climate adaptation strategies. Supreme Court of India in this case, the Supreme Court held that the Supreme Court.
Thank you very much. Now we hear the introduction as well from the National and Capodistrian University of Athens. You have 4 minutes too.
Can you hear me well?
Yes, we can hear you well.
Honorable judges and esteemed colleagues, after accepting the definition given by the proposition, the opposition asserts that states are not legally obliged to protect indigenous rights when implementing climate adaptation measures. This argument is based on exceptions to absolute rights, the principle of proportionality, and the urgency of climate action. Climate change threatens entire nations, devastates economies, and endangers future generations. While indigenous rights must be considered, no universal legal provision prevents states from prioritizing broader climate policies, as well as from refraining from protecting the rights of indigenous people. First of all, indigenous rights are not absolute. Courts have upheld that human rights, including indigenous land rights, can be limited in the public interest. In Chilcot's in Nation versus British Columbia in 2014, Canada's Supreme Court ruled that land claims could be overridden if consultation occurred and there was just a compelling justification. Expropriation laws allow governments to seize land for infrastructure, and the same principle applies to climate adaptation. The Paris Agreement in Article 4, though legally binding, functions as soft law, guiding climate policies without strict enforcement. This flexibility shows that states can, when necessary, limit the land rights for climate security. Secondly, as long as states respect proportionality, ensuring suitability, necessity, and balance, meaning the proportionality in stricto sensu, they can lawfully prioritize climate protection. Legal rulings reinforce this. The Urgenda versus Netherlands case in 2019 established that climate inaction violates the right to life according to the ECHR, and the German Constitutional Court in 2021 highlighted intergenerational justice. These hard law rulings confirm that decisive climate action is legally mandated. Meanwhile, soft law, like the Convention on Biological Diversity in Article 12, supports land use restrictions for sustainable development. Proportionality allows governments to limit indigenous claims while ensuring ethical and legal climate action. Furthermore, the urgency of climate change further strengthens this necessity. Rising sea levels, wildfires, and extreme weather endanger millions, indigenous populations included. Delays due to legal disputes obstruct climate protection. In Belo Monte in Brazil, indigenous communities were displaced for energy security. In Finland, in 2018, economic priorities outweighed reindeer herding rights. Even indigenous groups needing protection struggle, like Kivalina in Alaska, USA, faces relocation barriers due to strict land rights, proving over-prioritization can be counterproductive. Concluding our case, this is not about dismissing indigenous rights, but recognizing that no rights exist in isolation. Hard law mandates climate action, while soft law provides necessary flexibility. Prioritizing indigenous land claims without compromise risks delaying urgent action. A pragmatic, legally justified approach is the only way to protect our collective future. Thanks.
Thank you very much. Now we'll move to the first rebuttals. We hear first the first rebuttal from Desh Bhagat University team. I would like to give the floor then to Desh Bhagat University team for 2 minutes.
So, here are the rebuttals. Sovereignty and nationality interest versus indigenous rights. International human rights law mandates that state actions, regardless of national interest or urgency, must not disproportionately harm vulnerable populations. Treaties like the ICCPR and ICESCR require equal protection for all citizens. In practice, effective adaptation does not need to come at the expense of indigenous rights. Rather, incorporating indigenous voices can lead to more sustainable and currently sensitive policies. Ambiguity and non-binding nature of some instructions. While UNDRIP is indeed a declaration, its principles have significantly influenced customary international law and national legal frameworks. Moreover, binding treaties like ICCPR and ICESCR clearly set forth obligations regarding not discrimination, and the protection of human rights. International and regional human rights bodies have increasingly applied these principles to environmental policies, reinforcing the idea that states must consult and respect indigenous communities even when urgent adaptation measures are required. National discretion in implementation. While national discretion is recognized, it doesn't absolve states from their international commitments. Judicial decisions, such as those in West Tingini and Samarkand, underscored that meaningful consultation and respect for indigenous lands rights and non-negotiable. Even when adaptation measures are urgent, they must be designed to minimize adverse impacts on indigenous rights. National policies can and should integrate protective measures without sacrificing the overall efficiency of adaptive efforts. Balancing.
Thank you very much. Just for information for both teams, you can finish your sentence. It's not forbidden to finish a sentence when you see the red card. Now I will give the floor as well to the team from Greece, National and Kapodisian University of Athens. For your first rebuttal, you have 2 minutes.
Honorable judges, esteemed colleagues, in my speech I will mention why the ILO and all the similar mechanisms that the side of the proposition has proposed can be overridden and in fact are mostly soft law. I will focus on 3 main points in my speech. Firstly, on the non-binding nature of indigenous rights. When it comes to those provisions, the picture becomes clear. Many of the obligations related to indigenous people, such as those found in the UN Declaration on the Rights of Indigenous People and the principle of free, prior, and informed consent, are based on soft law, not on binding enforceable duties. Treating them as legally binding misinterprets the state's consent to be bound by those, violating the general rule of good faith interpretation under the Vienna Convention on the Law of Treaties. Secondly, the ILO and the Paris Agreement do not have a strong enforcement mechanism, such as the European Convention of Human Rights, which do have enforcement mechanism, making them legally less important compared to the conventions that do affect certain deviations from the rules when it comes to situations of crisis. And thirdly, we are talking about situations of crisis. Article 8 of the European Convention on Human Rights mentions that restrictions on individual rights can be lawfully restricted if they're necessary in a democratic society and are justified by public safety and the protection of rights of others. The Intergovernmental Panel on Climate Change has highlighted the severe long-term impacts of climate change, including increased ill health, and premature deaths, with particularly devastating effects on vulnerable populations. In this context, it is necessary to protect people by making sure that we have the most important projects getting implemented as fast as possible. The evolutionary interpretation of those conventions makes it necessary to factor in the intent of the state, which is to protect the people. And we are the side that better protects people. Thank you.
Thank you very much. Now we move to the second rebuttals. So we start with the second rebuttal by the team from Desh Bhagat University. You have 2 minutes.
So okay, so let's start the rebuttal. I will state 3 arguments which has two points. So let's start with my first argument, which states that human rights are not negotiable. So as the opponent said that there are both soft and hard law, it is agreeable that there are both hard and soft law. Everything has pro and cons. So not go there, because if the laws are made, they are for the beneficial of indigenous people, which includes materialistic and non-materialistic things. So climate adaptation cannot be an excuse to violate fundamental rights. International law, including UN, DRIP, ICCPR, and the Paris Agreement, explicitly states that indigenous people have the right to free, prior, and informed consent before any project affects that land, culture, or way of life. No crisis, environmental or otherwise, justified the erosion of human rights. So human rights cannot be violated by anyone. Indigenous knowledge enhances climate adaptation. My opponent suggests that indigenous communities hinder climate projects, but in reality, they are key allies in the fights against climate change. Study shows that indigenous managed lands more store more carbon, preserve biodiversity, and sustain ecosystem better than state that control project. My third very argument states that false dilemma between climate action and endangered rights. Some may argue that prioritizing endangered rights slow down climate initiative. This is a false dilemma. Countries like Canada and Norway have successfully incorporated endangered leadership in climate policies. My fourth historical precedent shows that the danger of ignoring endangered rights are more downable than any other thing. The forced displacement of tribal communities in Amazon, the Maasai in Tanzania, and the Ognik in Kenya for conservation projects has led to human rights violation, economic struggle. Thank you.
Thank you very much. Now we hear the second rebuttal on the side of the National and Kapodistrian University of Athens. You have 2 minutes.
Honorable judges, esteemed colleagues, we oppose the notion that state obligations in human rights should be interpreted as an endless mandate for compliance at all costs. The European Court of Human Rights margin of appreciation doctrine, which also correlates to the Inter-American Court of Human Rights, clearly establishes that national authorities are best positioned to decide how to balance individual rights with pressing state interests. Ensuring effective state functioning and separations of power demands flexibility in such sensitive issues regarding conflicting rights. Therefore, international courts need to refrain from strict enforcement of the indigenous rights that side proposition is talking about. This gives government the necessary flexibility to balance their sovereignty with their obligation under the convention. Given that adaptation measures are often interlinked with state legal responsibilities, as proven in the Billy and Australia case, and that states need to take immediate action, they should enjoy a wide margin of appreciation. This accounts for the pragmatic consideration which has reinforced the case of Link and Northwest Indian Cemetery Protective Association, which affirmed that the government could not operate if it were to require every citizen's religious needs and desires in a society as diverse as their own. Getting indigenous peoples prior and informed consent may increase the cost of the project due to negotiations, leading to less projects getting implemented, or delay them, leading to people suffering longer the adverse effects of climate change. In the face of crisis, even if we consider free, prior, and informed consent customary law, it is necessary to enforce the principle of pacta sunt servanda, which make it necessary to accept violations that justify the public interests. Government must have the ability to balance this interest with broader societal concern, especially in climate resilience and public protection through a narrow interpretation of their obligation. This is a conditio sine qua non for state sovereignty and practical governance. Thank you.
Thank you very much. Now we move to the conclusions. We start with the conclusion by Desh Bhagat University team. So I give the floor to the team from Desh Bhagat University for 2 minutes.
So here are some landmark cases which support this. So first one is Avas Tingini Community versus Nicaragua 2001. Overview. In this seminal case, the Inter-American Court of Human Rights held that Nicaraguan government violated the territorial rights of the Avas Tingini community by failing to protect their ancestral lands. Significance. The ruling underscored that states must consult the indigenous peoples regarding decisions affecting their lands. Although not specifically about climate adaptation, the decision establishes a legal framework ensuring that any government action environmental policies include must respect indigenous rights. Here are some national statutes and laws also. Canadian law recognizes the rights of indigenous peoples through both constitutional provisions and specific statutory measures, policies impacting indigenous lands and resources, including environmental and climate adaptation measures required through consultation and respect for indigenous legal traditions. United States. Although the US does not have a law dedicated solely to indigenous rights in the context of climate adaptation, the National Environmental Policy (NEPA) mandates environmental reviews that often incorporate assessments of impacts on indigenous communities. Various states' law further support indigenous participation and protect against adverse impacts. Conclusion. Critics may raise concern regarding national sovereignty, the urgency of adaptation measures, or the binding nature of certain international instruments. However, the rebuttal demonstrates that international human rights law, reinforced by influential case law, clearly requires states to integrate indigenous rights into climate change adaptation measures, respecting these rights to not only a legal obligation but also a pathway toward more sustainable and effective climate policies.
Thank you very much. Now we hear the conclusion by the team from National and Co-Israeli University of Athens. You have 2 minutes.
Sorry, may I have 1 second only to review slightly my notes?
You are supposed to start now. So
Okay, no
yeah.
problem at all.
Yeah.
Okay, yeah, no problem. Okay, so I start in 3, 2, 1. Honorable judges, to decide on whether the state should protect and prioritize the rights of indigenous people when it comes to climate change measures, you have to make 2 comparisons. First of all, you have to ask which rights are more legally binding under international law. To all the instruments of law that the proposition team has offered you, Leonidas in his rebuttal had proven you either that they are soft law and therefore non-binding, or that to the extent to which they are binding, they certainly accept limitations. On the contrary, Mariah of your speech has connected for you the right to protection from climate change to the right of life. The right of life not only is hard law under most legal system, but also doesn't accept any exceptions. That means that when it comes to the comparison between those 2 rights, the state must always preserve the right of life and to not be harmed by environmental changes. Secondly, you have to ask which approach is more realistic. Overriding indigenous rights, as Mariah showed you, in some cases in the only way to protect people from an environmental crisis, as long as the principle of proportionality is fulfilled, as Chilcotin's nation case shows you that Mariah has mentioned. The proposition team has not provided you any alternative to show how the right to life can be protected even by balancing at the same time the rights of indigenous people. The proposition teams claims that human rights are non-negotiable. However, they fail to take into account all human rights. When a state has to take decisions regarding its sovereignty and its policies, it has to take into account all human rights affected by one situation. It can't take into account absolutely the rights of indigenous people. What it has to do is find a fair balance between protecting the rights of those people, but most of all, prioritize the right to life of all people of the nation that are possibly harmed by climate change. Therefore, we urge you to vote in favor of us. Thank you.
Thank you very much. So we just heard both conclusions, so it means from now you are not under evaluation by the judge. So you can breathe, you can take a sip. Now we are in the post-match phase of the session. So I will ask you, of course, your impression on this match, how you prepared it, the performance of your team and the opposing team as well. And then we'll finish with a bit of networking between the 2 teams. So now we'll ask first Miss Stamataki, what was your impression on this match and the preparation, the performance of both teams?
The truth is that what I loved more about the topic of this match and the preparation is that it was so interesting and so unknown to me until now that I could talk, for example, with my friends or my family about it, and they were all excited about what I was doing and what I was going to debate upon. So it was a sincerely interesting match, and also debating with people from literally another continent is so interesting, and it makes me really happy to be here. It was a very interesting match.
Thank you very much. Miss Manchakana, what did you think about the match?
The match was very interesting. The both parties have did very well. So let's not go to the conclusion of this match. The match was very interesting. We were very before this match we were very nervous what to do, how to do, and when to do, because this is the first time we are participating in a national tournament, international tournament. So yeah, it was very interesting. The topic was very interesting. It has more. It is more complicated topic then complexity in this topic. So yeah, if we go through states, we have to clarify what states are meant, which we can say in a different country the states are meant by national by the states by meant by national name, or we can say that everything has in this topic is bit different from each topic which have been prepared by any other team, or we can say that the previous matches have been debated, because I have seen all of them are very 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 good. So yeah, the match was very interesting. I am glad to be here. I am not reaching to the conclusion, but yeah, my opposition was very good. Let's go. If we move to the further, let's see who will win this match. Thank you to the organizers who gave us opportunity to speak on this topic, and Mr. Lawrence have been notified. I have asked very times like what to do, sir, what has to be done, and like what should be done and how I should prepare this. And he is very cooperative person. He have like whenever I have mailed him, I guess in 1 hour or two he have replied me with every solution. And yeah, I am very lucky that I have a mentor who teach me very well. My teachers from my university have also give us a very, like you can say, very like how you can do it, you don't have to be nervous there, you just go do it well, and we are seeing you from behind. So yeah, it was very, my family was also actually my family is also watching this match from YouTube link. Then I guess I will ask them what I have did in this match. So yeah, I am very happy. Thank you.
Thank you very much. Just mention that I'm neutral. Huh? I just reply emails from the teams who contact the Corax Foundation, my colleague as well, and we give the same information to all the teams, obviously. Many thanks. Now I give the floor to Mr. Leonidas Tsausis. What do you think about the match?
I thought the match was really interesting, and I think it was quite clear we both disagreed on certain aspects of international law, and I think that's what's beautiful about it. That we live in different countries with very different legal orders, but we have the same international law above us, and I think this is something that connects us all. And I think it was a really interesting discussion, and I thank everyone for participating here.
Thank you very much. Miss Gupta, what do you think about the match?
First of all our opponents and all our friends did very, very well. We got to learn many things from you, and maybe you would have also learned something. And matching with this first match, having a final match with in front of our judges, it was really enthusiastic. And one of the most important topic, like indigenous people, India is full of indigenous people. It's diversity, full of diversity. So in favor was kind of helping. And thank you so much, all the friends, and how cooperative you have been with us. So thank you so much, and all the best for future.
Thank you very much. Miss Berchetti, what do you think about the match?
Okay, first of all, I want to thank everyone for their insightful speeches, because I have the feeling that every one of us was very well prepared, and I really like what was said. And except for that, I have to say that at the beginning, when we first read the topic, we were a bit like more skeptical if we had the opposition side, because we said that maybe it's a bit heavy prop and we didn't know what it was going to be. But I think that we worked so much on the opposition that at some point it grew on us, and we were prepared for both. So this was also good. And we also found the topic really interesting because we could combine it with many fields of like our studies, civil law, environmental law, everything. So we really liked it, and thank you again.
Thank you very much. Now I give the floor to one coach within the room at this moment. What did you think about the match? I precise that Miss Oyesamni has been herself a debater some years ago in this competition.
So congratulations, everyone. This was really an interesting match with different sorts of ideas. We could really tell that everyone tried their best, and so I think you can really be proud of yourselves, because I can see that everyone tried their best. And it was interesting because not only do we debate about the nature of certain rights, about which rights takes precedent, etc., but it's also a very interesting use of case law that was required. So it was very interesting to listen to.
Thank you very much. So now we move to the very last part of this session. So it is more about knowing yourself. I mean, how actually you came to this competition, and as well a bit about your country or region of the country where you are. So we start first asking per team. So it means you can decide who want to answer first, of course. So we'll ask first Desh Bhagat University. How did you decide and why did you decide to participate to this competition?
Sir, actually, this is very interesting thing which I have. Actually, I have seen this competition through Instagram. I was scrolling one day and I was like, this is interesting. So I was like, I filled this form and I got reply. Then I thought I was like, I should not do this because it was very first time I have debating. I have debated in my inter-university competitions, but when I asked you for the friendly match, I was very nervous when you said that you have to do this and this. I was like, yeah, I have to do this. So that's when, and I think for a better understanding, it is more for communication skills. If we can work on our communication skills, we can work on our legal skills, we can through this competition we can understand that how a legal system works in different country. We cannot go there ourselves, but we by understanding the nature of debate the other parties are doing, we can understand the nature of legal methods which are have been dealt in a country. So yeah, that is more, I guess, I have been observing through the match, like what are the laws they have and what the kind of people they have, what are the attitude nature should a lawyer have. So yeah, many opponents were before in also a friendly match. I have observed very well. I was working on myself. So yeah, I aim to be a better person through this match. So yeah, thank you. I would like to say that.
Thank you. You want to add something, Miss Gupta?
Actually, I got to know about this competition only through Mansha. She told me about this, and she with trust she came to me that yes, you will be my co-partner in this, you will be my co-teammate in this. So yes, I'm honored by her that she chose me for this international debate competition. So it's a very big deal for me to be here to debate with these mindful people. So it's just a big deal. Thank you for everything.
Thank you very much. Now, same question to the team from Athens. How did you choose? Why did you choose to participate? And maybe how you got even selected? I don't know if there was a selection or a process. So, who wants to start?
I would like to start.
Mhm.
Okay, so first of all, we would like to say that we think that our shared passion for debate and international law is what has driven us to take part in this debate. And we really believe that we had so many things to gain from an international context because we knew that it would be like a multicultural debate. We would get in touch with people from all around the world. And we also knew that we would delve into topics that would be related to international aspects and how we can be more cautious, let's say, about the international stage. And it was also such a great pleasure because I'm gonna begin with Pelina. We had the luck to do our study abroad together. So when we found out that we were collaborating together, we were more than happy about it. And it was so exciting to be working with a friend. And after a point, when we got to know Leonidas as well, because we didn't know him, he's such an amazing colleague. And at this point, we're gonna say friend. And I think that it was really nice working with everyone under this context because we helped each other. We put a lot of work into this. And right now we're meeting so many amazing people, as I said, around the world. So, yes.
Thank you. You want to add something, Mr. Osis or Miss Stamataki?
said everything for all of us. Me, I am completely agreeing with you.
Yes, me too. I think it's an amazing opportunity that we're very privileged to participate in. It combines both law and debate, which are things that I think all of us love here. And it has been so enriching already, and I can't wait for what's coming.
Thank you very much. Now we have a last question for both teams. What would be, I mean, this is a question for the team from Desh Bhagat University. What would be the first food that the Greek team should try if they land in Punjab in your city? What would be the first food they should try?
Saroo ka saag makke ki roti. Best in winters. And if they are coming in summer, that should be rajma chawal. And if they are coming in monsoon, that would be pakode. If like with this changes from you can say season to season. Yeah, but if they are coming in winters, I would prefer them to eat saroo ka saag makki ki roti because they would gonna love it. Yeah, I can say sure that.
Ms. Gupta, you want to add something? Yeah.
As I like sweets, so lassi, the curd, the sweet curd, lassi, and gulab jamun. If you have heard about it, gulab jamun, it's hot sweet, so pouring sweetness. So it's just amazing if you prefer sweets.
Thank you very much. Now, same question for the Greek team. When the Indian team will come to Greece, what they should try first?
Okay, my favorite thing in the Greek cuisine is maybe the Greek salad. That it has tomato, feta cheese, cucumber, olive oil, peppers, and things like that. And it's very refreshing for summer. And also here it's very hot at summer, so it's also necessary. And feta cheese is very special. So I think that would be my first thing. But I really appreciate mentioning sweets by the proposition teams because I'm a very sweet person, so I note them down. So in case we ever go, I will definitely try them.
Thank you.
We will welcome you. We will welcome you.
You want to add something, Mr. Tsaousis or Miss Berkiti?
Me personally, in Athens, I think I prefer going to Indian restaurants rather than Athens. So I wouldn't say I'm an expert on this topic.
Miss Berkiti?
And we would also like to add like 2 of our traditional dishes that you have to try. I know that they sound the most touristic, but it's moussaka, the first one. It's like an eggplant with minced meat, and sometimes they also do it vegan, so it's fine, cheese and all these. And the next one is souvlaki. It's like, I don't know how exactly to describe it, but it's like a pita bread, and it also has some meat inside, tomatoes, a traditional sauce called tzatziki, and French fries. So it's really nice, and I think you should try that.
So yes, so a lot of things to discover. Myself, I know a little bit of both, but yes, I would like to eat the original ones, of course, in your own countries. So many thanks. So this is the end of this session. The judge will have 2 business days to assess your match, so you can expect early next week to receive the results, so around Tuesday or Wednesday. And yes.
I
Yeah.
cannot hear you properly.
Yes.
I cannot hear you properly.
Yes, I will repeat. So, I was telling that this is the end of the session. It means concretely you will receive the results at the beginning of next week. The judge will watch the match over the weekend and early next week. And for the second match and third match, you will meet, of course, the universities which are in your group. In your group, you have the group C, and there are 2 other universities. One university is based in Chile, so you will have a match against the University of Chile, who is in South America. And you will have as well a match against Tallinn University of Technology, which is in Estonia, in the north of Europe. So these are the 2 other universities. They had their own match this week, day 1 match of the group phase, like you. So they will meet you in around 2 weeks. You will receive the topic of your match, which will be on another theme. It will not be environmental law. It will be connected to space law this time. And you will receive it, 7 days before your second match. So of course, check your email box and you will see. But in the meanwhile, you will receive as well the result of this match and the grading rubric from the three judges assessing this match. So many thanks to all of you, many thanks in Greece, many thanks in India, and we will see you very soon. So great start of the competition to all of you. See you soon. Thank you.
See you soon. Thank you. Bye.
Thank you. Bye-bye.